Good morning, and thank you for joining us. My name is Kelly Weiner, and I'm a partner at Scott Legal PC. And today we're going to spend some time talking about how to obtain a green card based on company sponsorship. So, a few housekeeping items before we get started. Some of you may know that Scott Legal was founded on an E-2 visa several years ago. Our founder is in the US on an E-2 visa and has been on several different visas, including an F1, TN, B, and H-1B. As such, we know what you're going through. The firm is a full service immigration law firm, and we offer immigration services in a number of different areas, including E2, E1, TN, L1, family immigration, national interest waiver, EB-5, extraordinary ability visas, company sponsorship visas such as EB-2 and EB-3, and more. At the end of this webinar, we'll send out several useful tools. One is the PowerPoint presentation that we'll go through today. Also a link to where you can download guides that go through various visa options in more detail, a link to sign up for additional webinars, and the webinar is being recorded and will be made available on YouTube. We will send the link for that as well. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos to YouTube. We will also send you a link where you can set up consultations to speak with an attorney. So as I mentioned, my name is Kelly Weiner, and I'm a partner at Scott Legal and have been processing PERM, EB-2, and EB-3 green cards for many years. For any questions you have during the presentation, please send them through the chat box, and we'll try to make time at the end of the presentation. And without further delay, let's get started. All right, so looking generally at how do you obtain an employment-based green card in the US, there are categories of green cards called EB or employment-based, and they're listed here. And we won't go through each one in detail since our focus today is the company sponsorship, which is EB-2 and EB-3. But just to briefly mention them, EB-1A is for individuals of extraordinary ability. EB-1B is for outstanding researchers and professors, so often people coming for tenure positions. EB-1C, multinational managers or executives, so people who are being transferred from companies abroad to hold a managerial or executive role in the United States. EB-2, so under this category, to qualify, you either have to have an advanced degree, which is defined as a U.S. master's degree or higher. An equivalent would be a U.S. bachelor's plus 5 years of progressive post-baccalaureate experience. Or if you do not have the educational background, you could qualify with exceptional ability, which is meeting 3 out of 7 criteria. It's a lower standard than extraordinary ability. There's two ways to qualify under the EB-2. One is the national interest waiver. So this is covered in other presentations that we have, but basically this is where you are asking the government to waive the normal company sponsorship process that we're going to talk about today. Because the individual is working on an endeavor of substantial merit and national importance and can prove they are well positioned to advance that endeavor and that it would be beneficial to the U.S. on balance to waive this normal labor market test and company sponsorship process. Also under EB-2, we have the PERM company sponsorship. So that's what we're going to focus on today. EB-3 for professionals, skilled and unskilled workers, also under the PERM company sponsorship. The way this is broken down is a professional is someone where the job offer requires at least a U.S. bachelor's degree or higher. Skilled or unskilled workers, skilled workers, the job requires at least 2 years of education, training, or experience. Unskilled workers is where it requires anything less than that. And there are limited green cards available in the unskilled workers category. EB-4 is we won't touch on that, but it encompasses many categories. It's kind of called a special immigrant, status EB category. And then EB-5, which is an investment green card. So that's where you're investing either $800,000 or $1,050,000, creating 10 full-time jobs. Again, we have other presentations that go over these categories in more detail. All right, so let's talk about the labor certification process, also called the PERM process. And this is, under the EB-2 and EB-3 categories that we just talked about. And this is really the process by which most US companies will sponsor a worker for a green card in the United States. And it's a three-step process. The PERM is kind of the longest step and the one that has the most, kind of steps inside of it. So first you have to draft a job description. And it cannot be just a regular job description where you're asking for the ideal candidate. In order to kind of test the labor market in a way that allows the job to be as open as possible to US workers, the government wants you to draft a job description that says what are the minimum requirements to do this job in a reasonable manner. While most companies, when they draft job descriptions, are looking for ideal candidates, they have to kind of rework that job description to make sure they're not asking for anything kind of over and above the minimum requirements. So, if they had to hire somebody off the street tomorrow to do this job at a minimum, what education, what skills, what experience would they need? And that's kind of drafting the job description. After that's drafted, you're going to file a prevailing wage determination request with the Department of Labor. And this is where you say, here's the job duties, here's the job requirements, here's where the job is located. And the Department of Labor is going to take all of that information and make an assessment of what is the proper occupation code and what is the wage, which is kind of looking at averages in that area for what the wages are. And is this kind of a level one, level two, level three, level four job? So obviously level one is more entry level. Level four is kind of the highest, most, experience that you would need. And the wages will be based on that. Once you get the prevailing wage determination, that is the minimum wage that the employer has to pay once the person is granted their green card in the future. And when you get the prevailing wage, because of how long processing times are, it's possible that the employer won't be actually paying that wage for another year or even 2 years because of Department of Labor and immigration backlogs and in backlogs and availability of green cards. So once you get the prevailing wage, which right now is taking about 6 to 8 months, that's when you can actually start the recruitment process, also called the labor market test. So this is where the employer has to actually post the job in multiple places, and the places that it has to be posted are based on regulatory requirements. For example, they have to post always with the state workforce agency in the state where the job is located. They have to post two, Sunday newspaper advertisements, in the newspaper of general circulation for the location of the job. They also have to post a notice of filing at the place where the employment is happening. So they have to physically post that so other workers in that office can see it. And then if it's a professional job, meaning it requires a bachelor's degree or more, then they also have to do three other mechanisms of advertisements from a list of 10, again, that are listed in the regulations. The recruitment process or labor market test takes at least 60 days. 30 days where many of the ads are running, and then during what we call kind of a 30-day quiet period, but the during that time the company still has to review resumes and see if there's any willing, qualified, and available US workers for this job. If they do find any willing, qualified, and available US workers, they don't have to hire them, but they cannot proceed with the perm. Because the purpose of this whole process is that the company is saying, we want to hire a foreign worker for this job. And the government says, if you want to do that, you need to first prove you cannot find somebody in the US labor market who can do this job. Who's a US worker. So if they do find a US worker, the process has to stop. They can always test the labor market again at a later time, but they would need to redo some of these, steps, like get a new prevailing wage. Uh, if you end the recruitment and you have not found any willing, qualified, and available US workers, then you would proceed to the next step, which would be to file a labor certification with the Department of Labor. The Department of Labor is taking right now about 14 to 16 months to adjudicate these labor certifications, so it is taking quite some time. The labor certification can either be approved, also called certified. It can also be denied, or it can be audited. And when it's audited, what this means is that the government will say, please provide proof of the labor market test, proof of, all of the steps that you've taken to, do the perm properly. And then, for example, like they will look at the resumes, they will look at the applicants, and they will make their own assessment. of whether the company has properly followed the steps and whether the perm can be certified. There are certain audit triggers. So, for example, if the job requires a foreign language and it's not very obvious why. So, if it's a job for a Spanish teacher, very obvious why there's a language requirement. But for most other jobs, having a foreign language requirement is going to be very, very difficult. There's a very high standard to meet if it's not kind of immediately apparent why someone must, speak that foreign language, such as they're teaching that foreign language. Also, requirements outside those normally required. So the Department of Labor has their own assessment of what they think is normal for various occupations. And for example, if you ask for 20 years of experience and they would say, well, we think 8 years of experience is normal, that could be another audit trigger. There also tend to be kind of trends over the years. Sometimes they will, audit kind of many unskilled workers cases all in one year, or in the past few years lately, they've been tending to audit people who are kind of on an E-2 visa and, maybe not working directly for the company. So there can be lots of kind of trends and important to kind of discuss with your attorney to see if there's anything specific so you can try to see if you can avoid that if possible in your case. So all of these filings we've been talking about are with the Department of Labor. They are not with U.S. Citizenship and Immigration Services yet. And as discussed, the timing is quite long right now. So if it's maybe, anywhere from kind of a week to a month or so to draft your job description, 6 to 8 months to get your prevailing wage, 2 months for the recruitment process, 14 to 16 months for the labor certification processing, you're already looking at kind of over 2 years, most of that taken up with just processing times. So you do want to plan ahead when you're doing a perm and just think about, does this employee have underlying status? Will they be able to extend that status? Are they on a category that allows for this dual intent? So these are all important considerations. Once you get your approved labor certification, then you can proceed with step 2, which would be filing Form I-140. This is a form that can be filed that is filed by the employer, and during this process, the employee has to prove that they meet all the requirements of the job. So if the job required a bachelor's degree and 2 years of experience, the employee would have to provide their bachelor's degree and the 2 years of experience generally earned before they joined the employer. Things like employer experience letters, verifications from HR, from old companies. These are very important at this stage of the process. In the I-140, the employer also has to prove that they have the ability to pay the prevailing wage or whatever the offered wage was, but it cannot be lower than the prevailing wage. And so this is where they're going to look at the company's financials. There's kind of some specific tests they look at. So they're going to want to generally see tax returns, audited financials. If it's a larger company with over 100 employees, sometimes you can have a CFO, write a letter explaining the company has sufficient funds. Additionally, if the employee is already working for the employer and already being paid this wage, you can include the W-2s, payroll, and maybe other documents as proof that they, have the ability to pay the wage. So the I-140 is kind of the only step of this process that you can, expedite right now, that you can pay an additional fee to get a response within 15 business days. That can be an approval denial or request for more evidence. And, if it's a request for more evidence or a notice of intent to deny, you're going to provide more documentation, and then they'll generally issue a final decision 15 business days after that if you pay for that premium processing. If you don't pay for premium processing, the processing times are quite long, even sometimes up to and over a year. Once you get the I-140 approval, now you're at step 3. And step 3 is the stage where the applicant applies for their green card. And there's 2 ways to do this, which we'll go over in more detail. So one is the I-485 adjustment of status in the United States. This is available for people who are in the US in a status that allows them to adjust status. There's also consular processing. This is where the applicant is going to leave the United States and go to a consulate abroad, generally in the country where they live or where they resided before moving to the US, and get the green card, through the consulate. In terms of timing, you always need to think, is your green card category current or not? So right now, EB-2 and EB-3 are backlogged worldwide with extensive backlogs for people born in certain countries, such as China and India. So that means that many people are reaching the I-140 step and then having to wait essentially, until they can file for their green card application. Sometimes the wait might be not too long because the PERM is taking so long, and your priority date for green card, the visa bulletin is set when you file your labor certification. So you file your labor certification. If you have to wait 15 to 16 months to get it back, you're waiting that year. And then when you look at the visa bulletin, maybe you only have to wait a couple of years if you're not in one of the extra backlogged categories. But you do need to build that delay into your planning. The delays for EB-2 and EB-3 worldwide are relatively recent in the last few years, but unfortunately likely to remain or get worse because new immigrant visas or an increased number of immigrant visas are not being, authorized by Congress. Family members can join your green card application. This would include your spouse and any unmarried children under 21. All right, let's talk a little bit more about the two green card options. So adjustment of status or consular processing. So with adjustment of status, as I mentioned, you do have to be in the US in a valid status. Often this is the case because most companies who are sponsoring someone are doing so because that person is working for them already and they like the job the person is doing. So if you're in the US, let's say you're on an H-1B, you're on an L-1, you can file your I-485 with US Citizenship and Immigration Services. While it's pending, you have the ability to remain in the US. You also have the ability to file for work and travel authorization. Um, Sometimes this is, helpful for people that maybe, with an H or an L, you have that ability to travel, on that visa. But let's say you're on an E2 employee visa and your employer is sponsoring you. Once you file your adjustment of status application, you cannot leave the US and re-enter on the E2 as you would be considered to have abandoned the adjustment of status application. So sometimes people will file for work and travel authorization just to have as a backup in case there's an emergency and they need to travel, or in case their I-94 like runs out and they want to continue to be work authorized. So these are good benefits they offer during adjustment of status. I will say things have been kind of shifting when it comes to the travel authorization. So that's something to keep an eye on, as the way that the government has been interpreting the travel authorization is a bit more risky than in the past. So people want to weigh carefully whether or not they really need to travel, even if they have an approved travel authorization. So most applicants will have an interview with the USCIS officer. It used to be the case that many interviews were waived for employment-based applicants because of the new administration. We're really not seeing that as much anymore. Many, many more applicants are being called in to be interviewed. So you do want to be prepared for that. You want to I'll talk more later in the presentation about the green card interview, but it is important to prepare. For consular processing, so with this option, once the I-140 is approved, that approval will be sent to the National Visa Center. You, the applicant, will get a welcome letter, and then you will fill out an online form called a DS-260. You'll submit supporting documents to the National Visa Center, things like birth certificates, marriage certificates, police certificates, other kind of biographical documentation. Once the National Visa Center reviews the documents, they will send the file to the U.S. consulate. An applicant will attend the interview at the consulate. They'll also do a medical exam. And if it's approved, you'll get an immigrant visa stamp in your passport that's generally valid for 6 months. You will enter the U.S. on that immigrant visa. And once you enter, your green card will be mailed to you after you enter the U.S., usually within a month or two. All right, a very common question is who can pay for green card fees? And there are restrictions here. So fees related to the PERM process, legal fees and other fees such as, fees to place the ads, they all need to be paid by the sponsoring employer. The government does not want, applicants or employees to be able to say to their employer, hey, will you sponsor me for a green card? I'll pay for the whole thing. The employer does have to pay for that part. Once you get to the I-140 petition and the green card petition, it's more flexible. Either the employer or the employee can pay these fees. All right, let's talk a little bit about dual intent. So dual intent is the concept that you can be on a temporary non-immigrant visa, such as an H, an L, uh, And you can also have the intent to stay in the US permanently and apply for a green card here. There are many non-immigrant visas that do not allow for this, that explicitly say you cannot, you can only get this visa if you intend to leave. This is a temporary visa, and you must have the intent to return to your home country, to depart the US when the visa ends, or, if you can also renew it. Um, there are some visas that do allow for dual intent, but these are much more limited. So the H-1B and the L are the only kind of visas that explicitly in the regulations list that they are dual intent visas. There is some kind of quasi dual intent language around the O, which is why it's listed here in the Foreign Affairs Manual. There is some language that kind of suggests that filing for a green card and getting an O temporarily are not necessarily inconsistent. Your intent is supposed to be assessed at each entry. So let's say that you are entering on an O temporarily and you plan to get a green card at the consulate. You can make an argument that you do not have intent to stay permanently because for this particular visit, you intend for this to be a temporary visit and you do plan to leave the US. But it is quite complicated and can be tricky, especially for applicants on visas that have very stringent standards about non-immigrant intent, such as the F1 student visa or the TN, work visa. All right, so when you are moving from a visa to a green card, very important to think about timing and your underlying visa status. So how much time is left on your visa? Some visas are harder to extend or subject to more scrutiny once an I-140 or green card petition is filed. So for example, if you are on an F1 student visa that requires this showing of, intent to depart, and you have filed an I-140 petition, that's something if you went back to a consulate, you would have to disclose that on your DS-160 application, and they could deny you based on that if they feel, well, now this person really does have the intent to immigrate. So you do want to think about that. Be strategic when the PERM is kind of going on. There's not anything on your record really as the employee. But once the I-140 is filed, you do have to, be thoughtful about that. So let's say you're on a TN and, you're in a position where you could file your I-140. You may want to, and your TN is going to expire soon in the next 6 months. You may want to renew your TN a little bit early so that you're not needing to deal with having an I-140 filed when you go to your TN interview, as they could certainly ask you about that. You want to consider, do you want to adjust status in the US or get a green card through consular processing? There are some people where an adjustment of status is going to be the right call because they can stay in the US while the applications are pending. Their family lives there. Their children can continue going to school without interruption. There are some people where, it may not be the right choice. Perhaps they're on an E-2 and they need to travel all the time for business and they cannot file an adjustment of status and then just wait for several months for a travel authorization to be approved. That in that case, consular processing may be a better option because you can go to the consulate to get your green card, and you can travel freely without any concern about abandoning the green card application. One downside is that you still need to have a valid temporary visa to continue traveling to the U.S. during that time. So if you file an adjustment of status and your visa expires or your underlying visa status expires, you can stay in the US based on the pending adjustment of status. But if you are going through consular processing and let's say your visa is expiring, you will not be able to kind of stay in the US just on the basis of the green card. You would have to either renew your visa or possibly even wait outside the United States until your green card can be processed. Also, you want to think about your family. Do you want your children to be able to be on your green card application? If so, you want to consider filing early because your children will age out at 21. All right, let's talk about some green card interview considerations. So what should you consider before the interview? You do want to review your immigrant visa petition and your green card petition, so the I-140 and the I-485, or if it was a consular processing, your DS-260, your package of biographical documents. You want to organize and print documents to bring to your interview, and you want to gather original documents for anywhere originals are required. So these are usually things like birth and marriage certificates, maybe police certificates. medical exams. So in the United States, with adjustment of status, the medical exam is completed on a form called an I-693. If you're going to the consulate, you will go to a panel physician. So this isn't just a doctor you can select. The consulate has specific panel physicians that have been vetted that they work with. And generally, you can only book an appointment after your consular appointment has been scheduled. So you do have to kind of build that into your planning that you need to make that time for that appointment. You want to get updated proof of employment from your sponsoring employer. So, if you're in the United States, maybe you bring an I-485 Supplement J. If you're at the consulate, perhaps you bring an employer letter confirming that they want to employ you in this job and for this salary. If you are adjusting status, you want to bring proof of your maintenance of status. So to be able to adjust status in the United States, you need to prove you have not ever, violated your status. And that includes your entire immigration history. However, if you have, you still may be eligible to adjust status based on a provision called 245K, which is a great provision for employment-based applicants that allows them to still adjust status as long as they haven't violated status, worked unauthorized, within for more than 180 days since their most recent entry. So while most of the time they're looking at your entire immigration history over the whole course of your life, 245K means they will only look back as far as your most recent entry to the United States. Um, so you also want to meet with your attorney and do a practice interview, or at the very least, review questions. If you don't want to do it with your attorney or you can't, practice with a friend. It can be a very nerve-wracking situation, and you do want to, even if you think you know the information, it's a good idea to kind of practice discussing it and saying it out loud, to make sure that you're prepared for the interview. All right, let's talk about porting and changing employers. So, as we've discussed, the green card process is very long. And a very common question we receive from people is, can I switch employers during this time? If I do, will I lose all the benefits of my green card process? And so, unfortunately, like let's say your company has started a perm for you, and you get a better job offer and you switch employers, the fact that a perm was started for you doesn't really give you anything. Your new employer is going to have to start the process all over. Even if you get to the stage where you have an approved I-140, that can be beneficial for kind of H-1B visa holders. They can sometimes use that to extend their status beyond 6 years. But even so, your new you may be able to use an older priority date, but your new employer will still have to do an entire perm for you. However, once you reach the end stage of the process, if you are doing an adjustment of status and your adjustment of status has been pending for at least 180 days, you can port. And porting allows you to change employers. You will have to submit a request to USCIS, and the new employment has to be in the same or a similar occupational classification as the job that was offered to you in your Form I-140. So let's say you have a whole perm approved as an accounting manager. And now you're being asked to do a job, as a VP of accounting. Likely you'll be able to kind of make that argument that this is at the very least a similar occupational classification, or maybe even the same. However, if you wanted to kind of take a really left turn in your career and move from a VP of accounting role to now you want to be an owner of a farm, that's not going to work. So it does have to meet this criteria of the same or a similar occupational classification. But there is a benefit in that your new employer in a porting scenario does not actually have to do a new perm for you. Important to note as well that you can port kind of even within the same employer, again, as long as it's a similar occupational classification. So let's say because this process has taken so long, the planned perm job has changed. And once you get to this stage of 180 days where the I-485 has been pending, you can potentially port, and that's going to get submitted to USCIS. They will review it and then kind of approve or deny that request. All right, another very common question. Can I change employers after I get my green card? And the answer is yes, you can. Once you obtain your green card, technically you could quit the next day and not and find a new employer or not work or what have you. The green card gives you that ability to kind of live and work in the United States, and your status is no longer tied to your employer. That being said, when you obtain this employment-based green card, when you go to the interview, when you submit the documents and the paperwork, you are making a good faith attestation that you intend to continue working for that company that sponsored you. So quitting, the day after you get your green card is something that could be looked at, as suspicious. Oftentimes where this might come up is, for example, during the naturalization process to become a U.S. citizen, they will look at, your employment history. They will look at the basis under which you got your green card. And if they look back at that and they feel, like, is there fraud here? Is there misrepresentation? That could be problematic for you, not only for your naturalization application, but if they really dug into it and felt that there was fraud in the green card application, even the potential risk to lose the green card. So, that being said, it is, let's say that you get your green card and then your employer fires you a week later. You don't need to worry about that. That's not your fault. You made the attestations. Ultimately, a business decision was made. That's really not on you. You can be able to explain that. You want to keep the proof that you were terminated. Uh, you know, that being said, if it's you and you're making the decision, probably a good idea to continue working for the employer for some length of time. You don't, you're not required to, and there's no kind of perfect length of time. Some people will kind of get like 6 months fixed in their head. So it's not the case that there's any particular number of months that will, make sure you're in the clear. It's just more, is there some explanation that's reasonable, for why the situation changed, where previously you made an attestation, yes, I'm going to work for this company, indefinitely. And why did that change? Did your spouse got a better job in another state? You were offered more money somewhere else. So these are kind of things to consider. All right, so we've come to the end of the presentation. And we do have, so someone has asked a question about a recording. Yes, this is being recorded and it will be made available on YouTube, and we'll send you a link for that. So somebody's asked a question. I want to bring my brother on a PERM EB-3 green card from India. What is the time frame right now? When can I enter the US? So it can be complicated to kind of bring a relative on the PERM process. It is something that has to be disclosed on the application. If you have a very large successful company that has, for example, its own HR department that you as the owner are completely separate from, if you have kind of other people with control over the company, you could potentially try to make that argument, but it will be a more challenging case if you do have a familial relationship with the applicant in terms of kind of specific timeframes. Timelines, paying, we went over paying earlier in the earlier in the presentation. So I'd encourage you to look back at that. And for any kind of very specific case specific questions, please set up a consultation. Someone's asked, as a business owner in the US, a similar question: can I hire my brother for a healthcare service? Again, as I just mentioned, you're going to have a much harder time with a green card case where the applicant is your family member. It's possible to do it. Again, it's going to be most viable in a situation where the company is very large and where there's other owners in the company besides you, so that there is arguably, other people making the decision during the labor market test. Otherwise, they just may not believe that this is actually a bona fide job opportunity being offered to U.S. workers during the labor market test. So I'm not sure what this means about other sponsors being necessary, but generally, if you own a company and you want to sponsor somebody for a green card and they are your family member, there is significant risk with that. So it appears we have answered all the questions. So thank you to everyone for joining and for your time and your great questions. And I hope you have a wonderful day. Thank you.